Well, good evening. It is 6 o'clock and we start on time and end on time because we're mindful of your time. Thank you, everyone, for attending this presentation tonight. We're glad you're here. As always, just a couple of things. My name is Angela Lopez and I am an attorney, immigration attorney with Cowles Thompson. And with me is my colleague, Michelle Alonzo. Michelle, we can hear you.
Good evening. Thank you for joining us.
Great. Okay, so housekeeping items, please remember this is a presentation. You're going to be muted through the presentation. The great thing about webinars or seminars is that you can type your questions as we do the presentation. There is at the bottom of the screen, or depending on what your computer setting is, there is a chat box. You can type your questions. We'll try to answer questions as we do the presentation, but definitely at the end of the presentation, we will have a time for questions and answers. Today is session or series, is the part 4 of our series, J-1 physicians. We're going to be talking about J-1 green card options. This is always the legal notice. You understand this is general information. Please do not apply to any specific facts or cases because may not apply to you specifically. If you have any questions, we'll be happy to discuss your specific case and be happy to answer any questions to your specific set of facts. I'm going to do a little recap of what we've done in the last 3 weeks. Today is our 4th week presentation. On November 9th, we talked about understanding the 2-year home residency requirement. And then we discussed that after J-1 waiver program, physicians, all physicians that have been sponsored by the ECFMG are subject to the 2-year foreign residency requirement, which means that physicians sponsored by the ECFMG at the end of the training program, fellowship, or residency, they have to go back home, and it might be home country or last place of residency or citizenship, even if it is dual citizenship. To stay in the United States, then they need a waiver, and there are waivers, and that's what we discussed in our presentation on November 16th. There are several waivers available. There are several in terms of the categories, but there are only 3 types of waivers: hardship, persecution, and interest government agency, or IGA. And that's the one that was the main focus of our presentation. There are many options there. Well, not many. Well, no, yes, there are many, but the most commonly used options are the Conrad 30 state program, 50 states, 50 different Department of Health, and they all can sponsor up to 30 waivers a year. So currently, the general requirements, 3 years contract and 3 years obligation and work location underserved areas. The Department of Veterans Affairs, they do their own waivers. The few times we've helped, the VA hospital has been with the H-1Bs, but now with the J-1 waivers. The Department of Health and Human Services, great, but mainly and only for primary care physicians. And it requires employers to be in underserved areas of at least 7, score 7. Appalachian Regional Commission, ARC, and Delta Regional Authority, DRA, they are kind of similar. They only cover certain regions of the United States, counties. They're specific. Sometimes they overlap. So people in these states or region physicians might have 3 waivers options: the Congress State 30, the ARC, or the DRA. At that point is what would help them the most. And then the latest program was the Southeast Crescent Regional Commission. That the good news about that one is that covers the entire state of Florida. So if by any chance you apply for a J-1 waiver or are applying for a J-1 waiver under Florida regulations or Conrad 30, And if you're not granted a waiver, you can still apply under this new program, and you might be able to get your Florida J-1 waiver. And the last one we did last week, it was about the obligations of the J-1 waiver physician that must work in H-1B status for full 3 years. That's the commitment. Give me my waiver and I'll work 3 years in H-1B status. Full time, we talked about 40 hours per week of 160 hours per month. Employee of a sponsoring employer, it cannot be a contractor or 1099. It has to be a W-2 employee. In some states, employers and physicians have to submit periodically compliance documentation, sometimes every 6 months, sometimes once a year. Some states don't even require that. And extenuating circumstances, and Michelle explained very well and extensively what extenuating circumstances mean. What that basically is, during the 3 years commitment, physicians are not able to change employers unless they can prove there were certain changes in circumstances that were not anticipated, were not caused by the physician, that makes it almost impossible to continue working with that employer, and therefore they have to change to a different employer, but still underserved area. And finally, we talked about how J-1 physicians cannot complete their green card process until they fulfill the 3 years requirement. And here is where we are today. So just to give you an idea of how easy the path to citizenship or permanent residency is for international medical graduates, I love putting on to view this slide. I didn't create it. Somebody did it, put it in the internet, and I have been using it for years because I think it's very helpful in seeing the options. So you do your medical education in your medical schools, whether it's in the United States or international medical school. Either way, if you're coming to the United States, you will be required to do residency program, regardless. U.S. citizens or foreign medical graduates need to start with a U.S. residency program. The choices are, if you are a foreign medical graduate, then you can have a J-1 visa or an H-1B visa. We know that in the last few years, most programs, very few programs do H-1B visas. Most of medical schools require J-1 visas, which subject ECFMG physicians to the 2-year foreign residency requirement. That's a given. If you are lucky and you find one of those programs to do the H-1B visa, then from the H-1B, you can go straight to green card path, whether you are married to a U.S. citizen or you have an employer that can sponsor you, great. You go straight to permanent residence. But if you are one of the international medical graduates that have to apply for a J-1 visa, then you're going to be subject to the 2-year foreign residency requirement, and therefore you will either have to go back home for last place of residence or obtain a waiver. That's right here under the J-1. If you obtain a waiver, either you obtain a waiver or you go back home. If you're going to come back or stay in the United States, you have to be working in H-1B visa for full 3 years. We put there other options, but for ECFMG J-1 physicians, the option is waiver, go home, and then H-1B visa. Once you have your H-1B visa, then your options for permanent residency, which is what we're going to discuss today, are a few. And with that, I'm going to pass the microphone to Ms. Michelle.
Yes, thank you, Angela. And as Angela mentioned, we are going to be touching on some of those options. This will be mostly just very surface and going over the requirements so that you're aware of them. But the fact is, once you're here and once you've gotten your waiver, there's a couple of different ways that you can go and pursue the green card, and you'll see those general options listed there on the slide. We'll be discussing briefly the labor certification, EB2, the National Interest Waiver, the physician National Interest Waiver, which is not to be confused with the general National Interest Waiver. EB1, aliens of extraordinary ability in their field. It's always a fun one to discuss. And then for those that are more academically inclined in terms of academia and research, we do have outstanding professor and researcher categories as well. And then the catch-all other, because as you know, life happens while you're here. Sometimes circumstances happen in your home country that will change your situation, or you get lucky and hit the lottery with a diversity visa. So those are all options to get the green card. And this is at this point in your career once we've managed the waiver portion. So the first one we're going to touch on briefly is the Alien of Extraordinary Ability, EB1. Now, this one is probably one of the most researched on Google categories, because it doesn't require sponsorship. It can be self-sponsored. You can self-petition, which is why a lot of folks are really keen to it. You can look on USCIS website and see all of the requirements listed. We'll go over them in these slides. But overall, you need to understand that this is for applicants who have risen to the top of their field or their field of endeavor. And you have to show that you're just in that upper echelon, that you're just separate and apart of everyone else in this field. So the requirements are, you must show sustained national or international acclaim, and that has got to be in the field of endeavor. So you'll spend a lot of time with your attorney going over the field of endeavor. Now, medicine is a huge field, but when we're talking with physicians, we have to narrow down that field of endeavor even more so, as you can imagine. Specializations are where they come into play, and we'll look and work with you on that as well. But you have to have either have one amazing national award that you get, like in the regs, they mention a Pulitzer Prize or a Nobel Peace Prize. Most folks, we could Google and find who have gotten those, and if they would qualify for EB1, easy. For the rest of us, or for the rest of the physicians that are looking at this category, we need to look and see if you meet at least 3 of the following 9 items that are listed. You'll see 1 through 4. All this seems very standard, you know, nationally or internationally recognized prize or awards, membership in organizations, published materials about your work, or judging the work of others. So many physicians will do peer reviews, and they're invited to sit on panels. Membership in organizations, we always explain, we're not talking about a pay for membership. This is one where you've been sought out, and there's a level of exclusivity that because of your accomplishments, you're a member of that organization. Or if it's a pay for organization, but you get access to a certain elite status, that would be one way as well. Publish materials about your work. It can't just be a brief mention of you was a part of a team. I know a lot of PRs for HR teams will put out little advisals. That's not it. You'll see on your screen the other 5 original contributions of major significance in the field. This is interesting because a lot of what medical research or folks in the medical field do, physicians, those original contributions are often very changes in methods, changes in approaches, changes in screening. So we like to get educated about what it is when we're talking about original contributions, and there'll be a lot that we'll highlight there. Authorship of scholarly articles. This is where Angela and I tell our physician clients all the time, please give us the most detailed CV that you could have, that lists everything, every publication, every trial, everything that you've done, because we want to see the breadth and the depth of your experience. Number 7, you'll see high salary or compensation. For a lot of physicians, that is fairly easy to meet in certain areas, but it's got to be comparable to others to show that there is a huge difference, that you're being compensated at a rate that speaks to your exclusivity or your notoriety in the field. Performance in a leading or critical role or distinguished organization. This is great. Other comparable evidence, pretty self-evident. Now, one thing we will explain is a lot of what physicians accomplish while they're seeking medical training oftentimes will come under scrutiny. They're wanting to see what happens post-graduation or post-placement as an active physician. So all things to keep in mind. Let's see. So, okay, a U.S. employer. Now, the next one we're going to talk about is outstanding professors or researchers. So This is unique. There's a lot of physicians that are really on the research side of things and teaching clinics. And once you're going more towards academia or these settings, we could possibly look at this option for you. Obviously, we're going to want to, and you're going to have the employer on board, right? And normally we're talking about university institutions, but it's got to be a U.S. employer. So this is not a self-petition. This is now participating with a sponsoring employer. Eligibility. We're talking about an offer of employment. Employers are going to own this process. So, Angela, you want to click on the next slide? Thank you. And there's very specific, employment must be a tenure track position. They are looking specifically for that language. I can't tell you how many times we've come back and said, is this tenure track or not? Because if it's not tenure track, we're not in the game for this category. That's very important, can't be adjunct. Research position with no fixed term in position. And it can be, you'll see with a private company, there are those requirements on there. Like I said, if this is your category or you see that this is where you might have an option, please contact us, because if your employer is willing to work with us, we could possibly qualify you for outstanding professor and researcher. Now, in terms of the applicant, what you have to demonstrate, again, this is borrowing a little bit from the EB1, you need to show that there's outstanding achievement in the field, that this is why you're being sought out to be an outstanding professor or researcher, not just any professor researcher, but outstanding. There's got to be that exclusivity, that notoriety that goes along with you. Again, membership in associates require outstanding achievements. Again, self-explanatory. Now they want to see about your publications and that you're judging the work of others. So there's peer review and those sort of occurrences happening in the purview of this employment. So if you are one of these potential applicants, you'll definitely want to look at this one. There you'll see the rest of qualifications, original contributions in the field. Now, original can be subjective. We can get a lot of letters explaining how original the contribution is. We can work with that. And again, authorship, if you're printing, that's why when you get your CV over to us, we want it detailing everything. But that's not it. Just because you check off all the boxes, think, okay, well, I have something that meets every category, we're good. Not exactly, because there is what USAS calls a final merits determination. And Angela and I like to talk about, it's not just quantity, it's quality. So you could meet and check off all the boxes and have something that fits in it, but what is the quality of that? Now, we'll have potential clients contact us and say, well, I've published at least 20 articles. I've chaired this, I've done that. Well, when we look at it, if it's just a variation of the same article that's been published in multiple places, it's not necessarily going to count. So we're really wanting to go into, and this is where we work with the client and you educate us a little bit on how we can make that distinction and whether or not there is a genuine quality assessment that we can meet and overcome the burden to get an approval on this type of case. So.
Correct. So the other option is a National Interest Waiver, NIW-EB2. For National Interest Waiver, you're going to see there are two types of waivers or two types of cases. One is the general, is physicians' research work, national interest and potential employment is required. And then we have the physician medical practice. That's the one we're going to be talking about today, because at the end of the day, we're talking about J-1 physicians who have obtained J-1 waivers. For the general physician research work, is a whole different set of rules, and that's similar to the one just Michelle explained for the researcher professor, but we're talking about National Interest Waiver, not necessarily extraordinary or outstanding professor. For the physicians, then what you want to know about this petition is that it's a self-sponsored self-employment petition. That means that when you file this petition, you do it on your own behalf. It's not the employer who's going to be sponsoring you, it's yourself. So you own the process. This is important because sometimes physicians do change employers during their professional life. Specifically, we're talking about certain physicians who might have wait many years to obtain a green card. And therefore that national interest waiver petition will go with them wherever they go. That's the good thing about national interest waiver. Requirements, well, they might be, and always is the same thing. People ask 5 years commitment, yes. But if you think about it, if you obtain a J-1 waiver, you're already committed to work in an underserved area for 3 years. The NIW will require to work 2 more years in addition to those 3 years in an underserved area. That doesn't mean you have to stay with the same employer for the full 5 years. You could, at the end of the first 3 years, J-1 waiver, decide you want to work somewhere else, and you can do it. The only difference is that you will have to update the USCIS records, filing a new petition to let them know, hey, USCIS, I'm working in a different underserved area, but I will still be working towards the 5-year national interest waiver, and therefore you will continue to work in an underserved area. That's the only catch. It's not like you completed the 3 years J-1 waiver and then you're free to go. You're free to go once you meet the 5 years requirement, which is very useful for physicians who are from countries that are subject to a priority date, and we'll talk about that briefly later. That for those physicians that might take more than 5 years to get a green card, the NIW is always a great option because they will not depend on any employer every time they change employers to sponsor them for green card. The work has to be in an underserved area, health professional area, mental health professional area, medical underserved area. It can be primary care or a specialty, they don't care. Full-time employment. For J-1 waiver, we saw that employment has to be, in general, 40 hours per week or 160 hours per month. Here, we're talking about what the legal definition for full-time employment is. And according to the Department of Labor, full-time employment is 35 hours a week. I know for physicians, 35 hours a week is probably part-time, but that's what for national interest waiver is considered full-time. You will need a statement or a letter from the Department of Health in the state where you're going to be working in the underserved areas that says that it's in the public interest that you work in that area. We always help out with this, so you need the contract for 5 years or in the letter to be able to file your national interest waiver petition. Just keep in mind this: for J-1 waivers, your contract is for full 3 years, and you cannot terminate it just because there's requirements, there's extenuating circumstances, there's a bunch of things. But if you add the 2 years for the national interest waiver, those additional 2 years you can terminate at any time, or the employer. So yes, the contract will read 5 years, but in practice, you won't be required to work the full 5 years with the same employer. Yes, in the underserved area, no to the same employer. If you change employers, you will have to go to another underserved area. The term of the 5-year commitment, you can complete it in more than 5 years. So for example, you started and you did your J-1 waiver 3 years. After that, you decided that you wanted to do a residency or fellowship, and you were able to get an H-1B. And then you go back to another underserved area and work the additional 2 years. So it took you 8 years to complete the 5 years. That's okay. It's allowed. You need to provide compliance documentation, meaning once you file for that green card, we'll talk about that later, then you have to provide documentation such as letters from the employers, tax returns, pay stubs, W-2s, to show that you did work the full 5 years in the underserved area, or in the underserved areas if you work in more than one underserved area because you change employers for the full 5 years. Then you have the other one, the other option, which is the labor certification, and we left this one to last because it's the one that we get more questions about, and is the one that I believe most frequently used to get green cards for physicians or for foreign nationals in general in the United States. There are a few considerations that you need to keep in mind when looking into processing a labor certification. And I think one of the most noticeable ones is that if you have some sort of ownerships in the sponsoring company, you own a number of shares, or you are partner, or half of the company belongs to you, you might have a problem processing your green card, because there is no self-sponsorship when it comes to labor certifications. We've done many labor certifications where the physicians are shareholders, but usually are minimum ownership, or if there is a significant ownership, then you have to prove that the employer has control of your employment and you were not part of the recruitment process. Physicians family relationships, if you wife, husband, brother, sister, or somebody close to you owns the company, that might also have some sort of impact in how you are going to process the labor certification. Why? Because the labor certification is a recruitment process that requires employers to prove good faith recruitment. And as I always tell the people that I speak with on my consultations, it is difficult to prove that if your wife owns the company, she's going to fire you, or she's not going to hire you because somebody else from outside came with better qualifications. That's not going to happen. So we have been able to do labor certifications for family members, but then what we normally require the employers is to look for outsourcing the recruitment and the interviews and the final decision as to who does the selection of the applicants, if there are any applicants, because if the Department of Labor is, and they will not yet, they will question the recruitment. You want to show, or the employers want to show, that they, not only them as family members, but the physician or the person they are had no involvement or decision making in terms of who was going to be hired, or they didn't even review the resumes. So it's doable, but a very objective way of recruitment has to be implemented. You also have to look at whether, whether there's been layoffs in the company that is sponsoring you within the 6 months preceding to you filing the petition. What we all normally recommend is that if there's been layoffs, to wait 6 months or longer before even starting new recruitment, because there are certain rules that have to be met, and that might affect the outcome of the labor certification. And finally, please take a look at, and coincidentally, I had a consultation today with somebody who's looking to do a labor certification, but he anticipates that maybe in a few years or couple of years or next year, there might be changes in the work location. Labor certifications are like H-1B visas. They are specific as to employer, work location, salaries, position, meaning job and requirement. So if you do a labor certification today for a person who is going to work at location X, and then when the labor certification is approved and you're going to file the I-140 or complete the green card process, that location X no longer exists, and the person is going to work at a complete different, another city location, not even within the metro statistical area, that will affect the labor certification. So you kind of have to anticipate certain things. No one can anticipate what is going to happen a year or 2 years from now, but that at the moment these applications are being done, be mindful of if there are changes coming up in the near future, you want to look into it before engaging in the labor certification process. It's expensive and it's extensive. What is it? Well, what are the requirements? Is employer specific? I mentioned that, full-time. Employer must conduct the recruitment with the Department of Labor, or based on the Department of Labor requirements. The recruitment has to be completed within 180 days from the first ad. That's a deadline. If you pass those 180 days, then the first ad is going to expire. And once it expires, you have to do another ad, and that might trigger that other advertisement might expire as well. You are doing recruitment seeking minimally qualified U.S. workers, U.S. citizens or permanent residents. Minimally qualified means that you cannot request excessive requirements. For example, for an extraordinary ability, you have to prove you're at the top of your field. For a labor certification, you just have to go what is normal within the occupation. So for physicians, normal requirements are obviously a medical degree, residency or fellowship, or residency and fellowship, maybe board certification or board eligible. Some jobs require experience, others don't. That's normal, depending on the type of specialty. But if you're going to say physician, we require the medical degree, the BCBE, and in addition, 10 years of experience, and foreign languages required, then you're getting out of normal, and that might trigger the Department of Labor auditing the good faith recruitment for that specific position. Employer must pay the prevailing wage minimum guidelines, and for that, before you even start recruitment with the employer, you submit a petition with the Department of Labor and you ask them to let you know how much the minimum salary for the area and the occupation that the labor certification is going to be done for will be. And the Department of Labor will let you know what is the minimum salary. Employer must pay at least the minimum or above for the labor certification to go through. Right now, I think that's what is causing the main delays when we do labor certifications, is the time the Department of Labor is taking to process prevailing wage determinations. Some of them have exceeded 8 months, but it's very common that prevailing wage determination takes somewhere between 6 to 10 months. It's not, because we don't want recruitment to expire. Remember, you have to do everything within 180 days from the first recruitment. You don't want to start recruitment and then complete recruitment and find out that you still have to wait 6 more months for the prevailing wage determination. Everything is going to expire. That means employer will have to pay for new ads, new posting, new everything. So we usually wait for the determination to come through to start the recruitment. Labor certification. So in general, and we could spend the whole hour talking about labor certification. So that's why we just want to give you enough so that you keep it in mind if you're going to talk to your employer, or if I have employers in our line, just to see what the process entails. 5 methods of recruitment that's required by the Department of Labor, very specific. So we usually help employers to do the recruitment according to the Department of Labor requirements. The ads must identify the employer accurately. You have to give a name and direct the responses, meaning if there's somebody who might meet the requirements, where the application should go. Whether it's going to be the employer's email or a specific address, but you have to let the applicants know where they can apply for the job. The ad must describe the job opportunity sufficiently to appraise applicants. What that means, if, for example, if we're going to advertise for an internal medicine position, well, the job title describes the job. So you don't need to say or too much than we need an internal medicine physicians. Any physician who is looking for a job and they see internal medicine physician, they'll know if they are internal medicine, they might qualify, but other physicians will know, I don't want that job, or I don't qualify for that job. So, but for other professions, sometimes it's not as obvious. So you need to put enough information on the ad to let people know what the job is about and what they are going to be applying for. The ad must contain the geographic location of the job. This is crucial. We talked about the labor certifications are work site specific. So you need to let the people know, where is the job located? Is it in Dallas? Is it in Modesto, California, or El Paso, Texas? whether it's in Miami, Florida, because they need to understand where they will be working to make a good judgment in terms of whether or not to apply for that specific job. And the wages do not have to be listed on the advertisement. However, they have to be listed in a couple of internal postings the employers have to do. Some employers like to put the wages in the advertisement to attract or not, depending on how many job openings they have. But if they are going to advertise the wages, they cannot be below the minimum prevailing wage that was established by the Department of Labor. Couple things. What are the obligations for the employers? Well, employers are required to pay all costs associated with the labor certification. That includes attorney's fees, advertisement, and the physician cannot reimburse the employer. That is prohibited by the law, and DOL is very specific as to who pays what. Most conduct good faith recruitment. And that goes to what we were saying before. Who is doing the recruitment? Who is involved? Physicians cannot be part of the recruitment. So something we do with all of our clients who we are helping with labor certifications is at the beginning, before we start recruitment, before the employer start pricing that, we might be able to talk to the employee to just gather some information regarding qualifications and other things. But once the recruitment starts, we stop communicating with the person who is being sponsored. At the end of the process, we go back to communicating because then we have to review forms before filing the petition with the Department of Labor. The purpose of the labor certification is to confirm for the employer, is to test the market, to make sure that they can attest to the fact that there are no qualified U.S. workers that responded to the recruitment, meaning no one applied that was either a U.S. citizen, a legal permanent resident, or someone who by law is authorized to permanently work in the United States, like people with asylum or certain special statuses in the United States. So for example, if an employer is doing the recruitment and somebody files an application, submits the petition, the application, and on the face of the resume or the application says, I need a sponsorship, or I am a J-1 physician, or I am an H-1B physician, employers don't even have to entertain that application because it's not a U.S. citizen or permanent resident or any of those workers that are permanently here in the United States. The employer has to prepare a detailed recruitment report. We always help them out with that in terms that we review the outcome of the interviews, the resumes and everything, and make sure that the report the employers prepare are accurate in terms of the information that was received, describing what were the methods of recruitment, the applicants, and the reasons for rejections if there were applicants that were rejected. And must keep records of the recruitment for minimum of 5 years from the date the labor certification is approved. Those are employers' obligations. Timeline for a labor certification. Determination of the prevailing wage is 6 to 8 months. That's the one that takes the longer. Recruitment is about 3 to 4 months, but less than 180 days. Department of Immigration, once we file, we see they are taking about 6 to 8 months to review a labor certification. If there is an audit means the Department of Labor comes back to the employer and says, we want to see everything you've done in terms of the recruitment and who's been involved. Then the process is going to take maybe up to a year for the DO to make a decision. Once the certification happens, the labor certification expires in 6 months, and the I-140 petition must be filed within those 6 months to avoid having to repeat the labor certification. Immigrant visa, this is just the end of the process. Once everything is done, you qualify, you apply for everything, then you have to file your I-485 adjustment of a status form or complete your consular process, DS-260. J-1 waiver physicians. This is the part that you cannot do until you complete the 3 years. So you can do your NIW, your extraordinary ability, your professor researcher, your labor, you can do all of that during the 3 years of your J-1 waiver obligation. But once you get to this part, even if everything is approved within 1 to 2 years from the 3 years, you have to put everything on hold. Once you complete the 3 years, then you can proceed with this last step to get your green card. Most people do the adjustment of a status or Form I-485 because they want to stay in the United States and work while the green card process is ongoing. This is affected by the priority date. Priority date, we just decided this morning, right, Michelle, that we're going to do a bonus presentation next week, and we're going to talk about priority date so people can better understand how it works or how it doesn't work, because it's a mess. And that is, you might not be able, even if you complete your 3 years J-1 waiver obligation, you may not be able to get your green card right after you complete the 3 years, because if you're subject to a priority date, for example, physicians from India, China, and couple other countries, they might have to wait for that priority date to become current. Many times after the 3 years, after 4 years, sometimes even after 5 or 6 or 7 years, to complete the last step. In the meantime, they might have everything in place to be able to continue to extend the temporary status, mainly H-1Bs, so they can stay here until they're able to complete the green card process. A quick fact here, and I just mentioned that you must complete your 3 years. I can never stress this enough. To complete your, there's only one tiny little exception, and I didn't put it here at purpose because people many times take it out of context. If you file your 485 based on the National Interest Waiver, you can do it before the 3 years. But then if you want to complete that waiver or that green card in the 3 years, you cannot use that I-485 that you filed before the 3 years. You'll have to file another 485. Mainly that happens when people have the National Interest Waiver and then they also do the labor certification. But that's the only tiny little exception. And again, even if you file it, you'll have to do the 5 years of the NIW to get your green card. So it doesn't really matter how soon you file your 485, the 5 years are the 5 years for purposes of the 485. Can hear you.
Perfect. So last but not least, and we want to be respectful of your time, other options. These are those others that I mentioned briefly at the outset. And as Angela mentioned, throughout this, there's exceptions that apply to almost everything that you've seen on this presentation. For example, one thing that we didn't update, that there are a few jurisdictions on the PERM process that have they're subject to equal pay transparency laws. So publishing wages may come in, and those are such few exceptions. The laws are so new in those jurisdictions. The mention regarding waiting for or when you can start and file the 485 based on the NIW. These are all these tiny little exceptions that can apply, which is why it's important that you reach out to us and consult with us so that we can help look at your separate set of facts, because you might have some of these other options available as well. A lot of you that come over as physicians, your situation and your family life may turn around. We have multiple physicians who come in and say, well, I married a permanent resident or I married a US citizen. Again, as Angela and I have stressed through all these, you will still have to meet your waiver requirement, but you may be able to switch to a family-based petition, for example, because you can have your immediate relative file for you, or you have a child who could file for you, or a legal permanent resident and you can continue in status and then file. Or if situations change in your country, and for example, we've had situations where physicians have been over and conflict has arisen, or something in their home country has paved the way to where they may have a claim to asylum because they cannot safely return to their country. So those are always options that you'll want to explore with an experienced immigration attorney. Over there to the right, you'll see lottery. The visa lottery is still an option. If you're from those countries that you can submit your lottery and do your submission, we encourage you to. Those are 50,000 immigrant visas. It is by sheer luck that these are selected. And if you're one of those lucky ones, you will want to go through this process. Again, each case is unique. Those are often, and those are always done through exclusively with the Department of State. So you'll want to be cognizant of filing deadlines and dates. And one option that's not mentioned there, because again, there's always is the EB-5. EB-5 is the investment visa. Those have set number, set amount that has to be invested. And there's various ways that you can within the EB-5 program possibly apply. We have physicians who have done the EB-5 route at the same time. And all these options that we present to you are because there's multiple ways to get the green card oftentimes, or sometimes there's just one, but you want to know your options and you want to exercise those options that you have available to you. Oftentimes, you may not know that you have an option, which is why it's important that we sit down and go over your CV and do the intake to figure out what is unique to your situation and how can we get you on the road to get your green card. All right, so I think, Angela, we can't hear you, Angela.
Okay, so now we're gonna go on for questions, and we do have a few questions here. So let me go through them, and hopefully we'll be able to answer each question. I answered a couple on the chat, so everybody was able to see it. But there was one here that started with the NIH and MD Anderson can provide J-1 waiver for excellent physicians. What is the type of waiver is? I'm sorry, if you want, we can discuss it offline. Give us a call and we'll be happy to talk to you about, but today is not about waivers. We did that last week, 2 weeks ago. So we need to move on with our questions, but please contact us offline and we'll be happy to talk to you about that. If we choose NIW to waive, we are also under the 3-year obligation, which means we cannot get permanent resident or change jobs in the first 3 years. But can we do that in the last 2 years? Yes. One thing that we mentioned is that the good thing about the National Interest Waiver, yes, you will need a contract for 5 years. And if you're already working on your 3 years, the amendment to the contract or the contract will state that you are adding a 2 year or 2 years to your contract, but those 2 years can be terminated at any time by either party, the employer or yourself. So that's not a problem. Can a person currently on H-1B J-1 waiver start the PERM I-140 during the 3 years waiver, assuming, and I imagine, I guess you want to say here I-485, not I-185, is filed after the 3 years J-1 waiver obligation completed? Yes, that's what we discussed. You can do everything before completing the 3 years, but the 485, you have to file it after completing the 3 years. That's a must, with the documentation to show that you did complete the 3 years. I just started my waiver. At what point do I start my process for NIW or PERM? Can I start both? Is there any reason to do both? Michelle, you want to tackle that one?
Sure. So as Angela mentioned, you could start, and we have a lot of unique situations where physicians will start the physician NIW, oftentimes because they want to have maybe a spouse gain access to employment authorization. So with the pending 485, we can request employment authorization. So there's a couple of reasons why you may want to. Again, you want to try to get your permanent residency, and if there's multiple ways that you can. Again, as Angela mentioned, the PERM is going to be based on priority dates. So why not go for those that are available? And the first one that gets you to your green card will be the one that you get your green card through. We just had a situation where we had a physician on a physician NIW and at the same time had done the EB-5. And because they were from India, there was priority dates that were controlling in that situation for the EB-5. We were just working through all that. Well, guess what? The first one that got to the approval was the NIW. So that's the one they closed out the other basis for possible green cards. So oftentimes we will counsel our clients that if you have multiple ways, try, because your end goal is to get the green card. And sometimes the other process may fall through for whatever reason. So we like to play it safe.
The other reason is, and that's good you asked that question, is many physicians, if you are from India, you do want to file your NIW petition immediately, as soon as possible, because that priority day, you want to be able to stand in line, and the NIW is going to get you to priority day sooner than the labor certification, and you want to secure that one. And then you can also do the PERM, like Michelle says, you can apply for as many options for green card as possible as you qualify for, that at the end of the day is the one that takes you there first. But if you are from India or China or one of those countries subject to the priority day, you want to start with the NIW. When you can start those process at any time, as soon as possible, if you are from a country that is controlled by priority dates, but you don't have to wait one day. You might have started your J-1 waiver today. You can start the green card process tomorrow. We had cases where we had started the green card before they started the J-1 waiver process. Doable. It's about timing and understanding the options and how you're going to play with the ads. And we love to call it strategize. Call us and we will be happy to help you strategize how, when, and the right way to do it. Another question came in. I currently have only a 3-year contract. Do I have to negotiate an additional 2-year contract with my employer before I start the NIW? If you're gonna go for the NIW, you will need that contract to read that is extended for an additional 2 years for a full 5 years. Again, the 2 years can be terminated at any time. Yes, we would prefer that you have the 5-year contract, but you don't have to do it before you start the NIW process, because you cannot really file. We can work with you and get petitions ready and prepare. And in the meantime, you can be working with the employer, but you want to make sure the employer is going to be okay with the additional 2 years, understanding contract can be terminated at any time, because sometimes employers don't want to, they are already committed through 3 years and they may now want to do 2 more. But when people bring up, well, we can terminate at any time, that eases their worries and they're more friendly to do the 2 years. So not negotiating as much to making sure the employer is going to go along with the 2-year amendment, because otherwise you're not going to be able to do the NIW. There is a self-sponsorship if you're able to show, and believe me, I have not done it for years because the Department of Immigration at some point decided that that's not a good idea. But they're used, and I did it many times. I had clients that signed letters and commitments that they will work the full 5 years underserved areas, even if they didn't have the full 5 years employment contracts, and they were committing themselves, and that was working well until one day the Department of Immigration decided, no, we're not doing that anymore. So that's why we go with the contracts. Any other questions, Michelle? Did you get any questions this afternoon?
No, I haven't gotten any more.
I got one in via email, and they ask about dependents. And I know we didn't mention dependents here, but dependents follow the principle. So whatever you can do to get your green card, your dependents will be able to get their green card through you. For children, though, is only until they are 21 years of age. Once they turn 21, the green card may not happen for them along with yours, and that's a whole different set of rules. But yes, your spouse and children under 21 not emancipated, meaning if you have a child who got married and is 18, out of luck. So yes, dependents are good and safe in terms of getting green cards with their principal parents. 3 years do I negotiate? I will finish my J1 in 6 months. My husband, who is Canadian, was offered, my husband, who is Canadian, was offered green card for me and him through his job, but was told that we cannot start the process unless I am done with my J1 waiver. You said the process can start, but his process can start. He can even get the green card before you. And then once you're finished with your J1 waiver, you can do what is called the following to join I-485 petition, which means I am the spouse. We were married before he got the green card. I couldn't do it because of this waiver obligation. Now that I can, I want the waiver of the green card through my spouse. So you can do it. That should not be a problem. Unless go ahead.
No, and I would wonder if they meant to start, because if we're starting as Angela covered, we start with the Department of Labor and the prevailing wage request, that's going to take anywhere between like 8 to 10 months or 12 months in some situations. So you'll be done with your waiver by the time they get the prevailing wage determination. So I think it's without knowing a little bit about where they mean where to start, they could definitely start and you'd actually be done. So whether you
don't have to be finished, but you can do it later. It's a matter of timing, and again, that should not stop his green card process. We'll be happy to talk to you about options, but if that's what the attorneys for the employers are saying, remember, if it is a labor certification, you are at the mercy of the employer. If they don't want to start now, very few things you can do to make them. But no, you don't have to wait that long. Chargeability, cross chargeability. That's a good one. Cross chargeability means you can claim your spouse's citizenship for purposes of getting the green card. So for example, you are from India and you're gonna have to wait 10 years to get a green card, but you marry a Canadian. So you can use your spouse citizenship, Canada, to say, hey, I'm sorry, I'm current, I don't need to wait 10 years for my green card, although I'm from India, because we're gonna use my wife's Canadian citizenship. So we should be able to get the green card now. Cross chargeability, we always use it every chance we get.
Absolutely.
I think we're done with the questions, other than the question about the NIA and MD Anderson waivers. I believe we covered all the questions today. Call us offline and we'll be happy to talk to you about those waivers. Thank you for being with us. We appreciate your time. Stay put. We'll do the priority day next week, and hopefully we'll be ready to help you out with your green cards as soon as the opportunity presents. Thank you.
Thank you.